Hi, I'm Ladan Korhani. I'm a family lawyer in Toronto and Simcoe County. Today, I want to tell you how you can bring an application to family court. If you are unable to come to an agreement with the opposing party with respect to custody, access, child support, property, spousal support, whatever the issues are, then you would bring it to family court to try to obtain a court order. Now, the term custody and access, it has actually changed, and now we refer to it as decision making and parenting time. But just to simplify things, I'm just going to refer to them as custody and access. Now, you are going to need three forms to bring this to court. So one is the Form 8 application. The other one is Form 35.1 affidavit and a financial statement. Now, the financial statement, we have two forms. One is Form 13 and the other one is Form 13.1. If there are no property issues, then you're going to have to bring just Form 13. If there are property issues, you need the Form 13.1. You can get these forms at the courthouse, or online, ontariocourtforms.on.ca. Now, let's start with the application. The application, the first page is just who's the applicant, who's the respondent. If you're the one bringing it to court, then you're the applicant and the respondent is the opposing party. Then you skip the rest of the page. You also skip page number 2. And so page number 3 is just about family history. You just fill out what it's asking you. Page number 4. So these are the claims. Claims means what are the orders that you're seeking. So you see there are claims under the Divorce Act. So if you were married or if you are married, these are the claims you're going to be check marking. So if you need support for yourself or it needs support for the children, again, decision making, same thing as custody, you just check mark those up, okay? However, if you are not married, then you need to go under the claims under the Family Law Act and check mark whatever applies. If there are property issues, then there's the other area where it says claims relating to property, equalization, exclusive possession, whatever it is that you're looking for, you're going to check mark that. Okay, so let's turn the page to number 5. So you can see on the screen where it says, give details of the order that you want the court to make. I know that there's almost no space here, so I always recommend, if you're not filling this out online and you can kind of make space, just add another page here and put here Schedule A, and on the page, the page that you're adding, just put Schedule A as well, so that the court knows what you're referring to. Here, you put whatever orders you're looking for. Are you looking for primary care of the children? Then you put that. Are you looking for the respondent to have parenting time? You put that. I always recommend, if children are involved, to put an order there for life insurance. Depending on the age of the children and whether or not children are actually involved, I would recommend that. Or if there are spousal support issues, so if you're looking for spousal support, I would also recommend that you put in there life insurance for yourself, just in the event something happens to opposing party. Okay. So then you go into where it says important facts supporting my claim for divorce. So if you're not married, you do not need to fill this out. Okay. If you are married, then they need the data separation. So important facts supporting my other claims. So the other claims are just what we just went through on page number 4. So these are the claims that you're making. These are the orders that you're seeking. Again, there's not a lot of space here, so I would put Schedule B and fill out a page or 2, because you want to start off with telling the court a little bit of the history. When did you first start either living together, or when did you get married? When did you get separated? The children that are involved in this case. What happened? I mean, was there abuse? Was there no abuse? you want to put in there, you want to explain to the court why you're seeking what you're seeking. So if you're seeking primary residence, you want to explain why. Have you always been the primary caregiver? Or if you're seeking certain parenting time for the respondent, then you also need to explain why. Okay, you want to explain your situation. So a lot of people don't fill this out. They don't know about it, but this is really important. Okay, this is kind of laying out your claims. So then we go on to page number 6. And if you don't have a lawyer, don't worry about the lawyer's certificate that says here. And it says here that you are, this is pretty much your signature. So you say your applicant's signature, you sign it, and you date it. This does not need to be commissioned. You can just sign it without a witness. And that's it for the application, okay? Now, this is insufficient to bring to court. The court also requires what I just laid out, the Form 35.1. So this is, I would say, it's a plan of care for the children. And you only need this if children are involved. So if you are bringing a claim for property and spousal support only, you do not need this form, okay? If there are kids involved, you need this form. So it asks you very specific questions. So, you know, they want to know if you have a criminal record, if you have, are you charged currently, have you been involved in another court case involving children. It's about you, and it's about the plan of care that you have for the kids. So I'm not going to go into detail with each page here. It's very, very self-explanatory, but you need to fill all of those questions. You need to fill them all out. And then you go to page number 5. It's paragraph number 15. You need to initial. And what this means is that if anything changes, you're going to need to update the court, and you need to initial that part. And then you also need to sign, but you have to sign in front of a commissioner of oath. What does that mean? Someone like a lawyer, a paralegal, but even the court clerk will do this for you, and it will be free of charge if you go to the court and have this done. So don't sign this. You just fill it out, but you don't sign this. There is another form. It's called the Form 35.1A. Now, this affidavit is only if CAS has ever been involved, the Children's Aid Society. So if they are currently involved, or if they have been involved, you need to fill this out. It's also a sworn document, okay? It's only 2 pages. So just fill this out if it applies to you, and don't sign it unless you're in front of a court clerk or lawyer or paralegal. Okay, so now we have all of that. Finally, we're looking at 2 financial statements. So one is without property issues, and the other one is with property issues. So the one without property issues, you need to make sure that you have your notices of assessment for the last 3 years. Without that, you won't be able to have any of this issue in court, okay? So make sure you have that. And just, I guess, the only reason an applicant would need a financial statement is if they don't have the children primarily, or if it's a shared parenting arrangement and child support might be an issue, or if Section 7 expenses are an issue. What's Section 7 expenses? That is when there are expenses related to daycare, medical expenses, and extracurricular expenses. So if you're making a claim for Section 7 expenses, you need to fill this out. If you are the payer and you don't have primary care of the children, or as I said, it's a shared parenting arrangement, you also need to fill this out. But if you are the primary caregiver, you're not making a Section 7 expense claim or spousal support claim, you do not need to fill this out. It's asking for your income, okay? So the first page, you need to also put if you are employed, you need to put the last 2 pay stubs. And if you're not employed, I guess they want to know how you're supporting yourself. So if it's through social assistance, then you just include that. And then the next page, or rather the page after that, so page number 3, it's just talking about your expenses. So it has it broken down, rent, property taxes, if that applies, water, heat, electricity. You kind of go on a monthly basis. This is monthly. So how much am I spending on a monthly basis on groceries, daycare expenses, so on and so forth. So you add it all up. And if you are living with someone else, it's asking you questions like that. That's page number 4. Any kind of assets that you have and debts, they need to be filled out as well. And then you go to the first page that you see where your signature is required. So again, you need to make sure that you sign this in front of a commissioner of oath. So please don't sign this. You need to sign it in front of either a lawyer, a paralegal, or the court clerk. Okay? So just fill everything out. And that's it if you're dealing with decision making, parenting, support issues, Section 7 issues. Okay? But if you are dealing with property issues, okay, that's a completely different form. That would be a form 13.1. And here, the first few pages are the same in that you need to write down what your income is and your expenses. But the sections that you see afterwards, it's very detailed in terms of your assets and your debts. So, for instance, this is all based on the date of separation. So on the date of separation, for instance, how much money did you have in your personal account? That's, for instance, an example of your asset that you need to put down. You also need to provide proof of that. So make sure that it's correct. Make sure that you go into your statement, print it off, and put the exact amount on there. So assets could also be, cars and property, land, boats, investments, bonds, savings, any of those things, anything asset. If you have cash at home in a safe, you need to disclose that as well. Okay? So all of those things you need to put with respect to your assets. Then we go into debt, same thing. Data separation, line of credit cards, student loans, mortgage. You need to disclose all of that. Okay? This form, it gets a little bit more complicated. You also need to, if you are able to, and you know that on the date of marriage, what assets and debts you had, you need to disclose that. Okay? So page number 6 on this one, it requires your signature. These are the ones that I'm talking about that require a commissioner of oath. Just know that this means that you're taking oath. These are sworn documents. So this financial statement form 13.1 also needs to be sworn. These are the ones that I'm talking about that require a commissioner of oath. Just know that this means that you're taking oath. These are sworn documents. So this financial statement form 13.1 also needs to be sworn. Okay? Now, you filled everything out. You were only really able to sign form 8, nothing else. My recommendation, this is what I tell people that are self-representing all the time, once you fill everything out and you have your notices of assessment attached and everything, just make 2 copies. Okay, so you have your original and you have 2 copies. You go to court, and in front of the court clerk, you will sign the original and all of the 2 copies in front of the court clerk. Okay, so you're swearing that the information provided is accurate. The court clerk will take the original from you. Okay, and you're now left with 2 copies. One needs to be served on the respondent, and just know that you personally cannot serve the respondent. It has to be anybody but you, and respondent has to be served personally, and you have a copy for yourself. Okay, so then this is the 2. You're left with 1 copy after. Whoever serves the respondent, when I say respondent, I mean the other party, your ex, they come to court and they fill out an affidavit of service. That's a Form 6B. What that is a sworn document that they serve the respondent, the method of service, the time and date, and it's as I said, it's a sworn document. It has to be signed in the presence of the court clerk, and that gets filed. So now the court knows that you have filed. The court knows that you've served your application. Okay. One thing that I think I missed here is that when you go there to have everything issued, the court clerk will give you the first court hearing, which is usually around 6 weeks, 7 weeks away. It's your first appearance court, and it's going to be on the documents that you're serving to the respondent, so that the respondent knows that they need to attend court. And that's it. This means that now you have started a court hearing, and without this, you can't go to court. This has now started the case for you. This is it for today. Until next time.